It gives me great pleasure to introduce Dr. C. Hariharan, a distinguished Sanskrit scholar, lecturer, writer, and orator. Dr. Hariharan holds a PhD in Sanskrit, specializing in Mimamsa from SV Vedic University, Tirupati, and completed his BA and MA in Sanskrit at the Madras Sanskrit College. He currently serves as the assistant professor and director of the digital campus at the Madras Sanskrit College, where he has played a significant role in expanding the institution's digital learning initiatives, reaching thousands of students through online platforms. In this session, Dr. Hariharan will take us through the topic Tools to Interpret Sanskrit Scriptures and Law through Mimamsa. May I now invite Dr. Sri Hariharan to kindly present his lecture. Thank you, sir.
Shri Gurubhyo Namaha. Hope I am audible. I need to see a thumbs up if I am audible. Yeah, thank you. Gurur Brahma, Gurur Vishnu, Gurur Devo Maheshwaraha, Guru Sakshat Param Brahma Tasmai Shri Gurave Namaha. Pamayojaka Varyebhyaha, Brahma Shri Venugopalan Mahodayabhyaha Mama Dhanyavada Purvakam Namaskaran Nivedayami. Ye cha pramukhaha atra किंचित कालतः प्राक् उपस्थिताः आसन् तेभ्यः सम्मान्येभ्यः रामनाथन् महोदयेभ्यः उमारामनाथन् महोदयाभ्यः च मम हार्दिक नमस्कारान् निवेदयामि. I would like to start my talk with an apology that I am not able to create a presentation, but past few days were very packed, and that is why I was not able to create a presentation. But I know the accusation the elders make that the students of nowadays will not be able to focus without any visual PPT or something like that. But I believe that Shastra students will be very much focused, and English is not my strongest suit. So I will read out whatever I have prepared. So yeah, here we go. So I would like to start this talk with a question. What is Mimamsa? Why should law students care? Or let me begin with a simple question. Whenever we read a text that contains rules, how do we determine what it really means? This question that arises in many fields. Lawyers interpret statutes, judges interpret constitutional provisions, and scholars interpret legal precedents. In the Indian intellectual tradition, a highly sophisticated discipline developed specifically for this purpose. This discipline is called Mimamsa. The word Mimamsa literally means deep inquiry or investigation. It is sometimes explained as Pujaniya Vicharaha, a respectful and careful inquiry. In other words, Mimamsa is not casual speculation. It is a disciplined method of examining authoritative texts. Originally, this system was developed to interpret the Vedas, which contain many statements relating to ritual duties and dharma. However, the interpretative tools developed in Mimamsa are not limited to ritual texts. They are actually general principles of textual interpretation, and therefore they can be extremely useful even in fields such as law. One of the central concepts in Mimamsa is the Adhikaranam. What is Adhikaranam? Adhikaranam is essentially a structured unit of discussion used to resolve interpretative doubts. Whenever a question arises regarding the meaning of a passage, scholars organize the discussion systematically. An adhikaranam generally includes the topic under discussion, the doubt or problem, a preliminary view, we call that Purva Pakshaha, and a final conclusion based on reasoning, we call that Siddhantam. If we look at this carefully, it resembles the structure of legal reasoning. In court judgments also, we usually see identification of the legal issue, presentation of arguments, analysis of the reasoning, and finally a judgment or conclusion. Thus, the very method of discussion in Mimamsa resembles a classical form of jurisprudential analysis. Another important concept in Mimamsa is the idea of Nyaya. A Nyaya refers to an established interpretative principle derived from careful observation and reasoning. Over time, Mimamsa Shastrakaras identified recurring patterns in the interpretations of texts and formulated them as general principles. These principles guide us in resolving ambiguities or conflicts within a text. However, not every argument becomes an accepted Nyaya. A valid interpretative principle must be consistent with the broader interpretative framework of the Shastram. This idea is very similar to legal reasoning. In law also, arguments become authoritative only when they align with recognized doctrines and precedents. Another way to understand Mimamsa is to see it as a science of language. It is sometimes described as Vakya Shastram, the discipline that studies how sentences convey meaning. So the Tarka Shastram, we call it as Pramana Shastram, and Mimamsa is called as Vakya Shastram. Texts do not interpret themselves. Meaning emerges only when we carefully examine the words used, their grammatical relationships, the context, and the intention behind the statement. For law students, this should sound very familiar because statutory interpretation also relies heavily on linguistic analysis. There is a beautiful verse that emphasizes the role of reasoning in understanding scriptural teachings. Bhattapada says, Arsham dharmopadesham cha Veda Shastra avirodhina yas tarkena anusandhatte sadharmam Veda netaraha. The meaning of this verse is quite profound. It says that the teachings about dharma given by sages and scriptures must be examined through reasoning that does not contradict the Veda and the Shastrams. Only a person who investigates them with proper reasoning, which is Mimamsa, he truly understands the Dharma. This verse reminds us that reasoning is essential for interpretation. Without reasoning, even authoritative texts cannot be properly understood. Among the interpretative tools discussed in Mimamsa, there is a very interesting method called Arthapati, Shrutarthapati, often translated as postulation or presumption. Sometimes a fact cannot be directly perceived or inferred, but it must be assumed in order to explain known facts. For example, if we know that a person, let's call him Devadatta, he never eats during the day, but is nevertheless gaining weight, we naturally conclude that he must be eating at night. This conclusion is neither direct perception nor ordinary inference. It is a necessary explanatory assumption. In law also, we often rely on presumptions, to interpret facts or reconcile evidence. Another principle emphasized in Mimamsa is what is called Vidhi Gaurava, the importance of primacy of injunctions. The Vedic texts contain many different kinds of statements, but Mimamsa pays special attention to injunctive statements, statements that prescribe action. This is because the central concern of Mimamsa is dharma, and dharma is something that must be performed or practiced. Similarly, in legal systems, many texts ultimately aim to regulate conduct. Classical lawgivers such as Manu also relied on scriptural authority when discussing dharma and law. But even authoritative texts require methods of interpretation. This is precisely where Mimamsa becomes important. It provides a systematic framework for interpreting authoritative statements. So I would like to now briefly summarize whatever I spoke in the opening discussion. Mimamsa is a discipline of careful inquiry into authoritative texts. Mimamsa provides tools such as structured discussion through Adhikaranam, interpretative principles called Nyayas, linguistic analysis through Vakya Shastram, reasoning tools like Arthapati, and attention to injunctive meaning through Vidhi Gaurava. Together, these tools form a powerful system of interpretation, and that is why Mimamsa remains relevant even today, not only for understanding Vedic scriptures, but also for reflecting on how we interpret laws and authoritative texts in general. Laukika Nyaya and Mimamsa Nyaya. Are Mimamsa principles derived from everyday reasoning, or do they shape everyday reasoning? When we talk about the tools to interpret the Vedas and law through Mimamsa, an important question arises. Where do the interpretative principles of Mimamsa come from? Are they purely philosophical constructs developed by Mimamsa Shastrakaras, or are they actually derived from common reasoning used in everyday life? This question can be framed as, are ordinary reasoning principles used in Mimamsa, or do Mimamsa principles influence the reasoning used in the world? A very illuminating answer is given by the great Mimamsa scholar Kumarila Bhattapada. In Tantravartika, he states, Mimamsatu lokadeva pratyaksha anumanadibhihi avichinna sampradaya pandita vyavaharaihi pravritta. Nahi kaschidapi prathamam yetavantam yukti kalapam upasamhartum kshamaha. The meaning of this passage is extremely important. Bhattapada says that Mimamsa did not arise in isolation. It is rooted in the natural reasoning processes that already exist in society. Human beings constantly interpret statements, whether they are instructions, agreements, promises, or rules. In doing so, they rely on basic reasoning tools such as direct perception, inference, context, established conventions, practical wisdom of learned people. These methods are already present in everyday communication. Over time, Mimamsa Shastrakaras carefully observed these reasoning patterns and systematically organized them. This gradual intellectual effort eventually produced the Mimamsa system of interpretation. Kumarila Bhattapada therefore says that no single person could have invented such a sophisticated system of reasoning all at once. It evolved through an unbroken scholarly tradition. This is where we claim to say that Mimamsa is in a very same way Apaurusheya as the Vedas are. because in Vedas itself, the interrogation is called as Mimamsa. For an example, there is a verse in Krishna Yajurvedam says, Utsrijya no tsrijyam iti mimagum sante. So this interrogation is timeless tradition. So this idea is very similar to what we see in legal reasoning. Courts do not invent interpretative rules arbitrarily. Many peoples evolve, many principles evolve gradually from judicial practice, precedents, and practical reasoning. In that sense, Mimamsa resembles a classical jurisprudential tradition. Mimamsa Shastrakaras essentially perform three intellectual operations on ordinary reasoning. Krodikaraha is one among them. Systematic collection. The first step is collection and consolidation. In everyday life, people interpret language intuitively, but these practices are scattered and are informal. Mimamsa Shastrakaras carefully observe these patterns and collect them into a structured framework. For example, when interpreting a statement, people naturally consider the context, the purpose, and the relationship between different statements. Mimamsa Shastrakaras gather these patterns and formulate them as interpretative principles. In legal terms, this is similar to how jurisprudence systematizes judicial reasoning. And the second thing is parishkaraha, which is refinement. Once these principles are collected, scholars critically examine them. They ask questions such as under what circumstances does a rule apply? What are its limitations? How should conflicts between rules be resolved? Through this analytical process, the principles become clearer, more precise, and more reliable. This stage resembles what legal scholars do when they clarify doctrines and interpret precedents. And the third thing is Vishaya Vishaya Chintanam, determining the scope of that principle. The third step is determining the scope and applicability. Not every interpretative rule applies in every situation. Therefore, Mimamsa Shastrakaras carefully examine this, where a rule applies, where it should not apply. This analysis ensures that interpretative principles are used appropriately and consistently. In modern legal language, we might call this determining the jurisdiction of scope of a principle. This discussion is highly relevant to law students, I believe. When judges interpret statutes, they also rely on structured reasoning tools, literal interpretation, contextual interpretation, purposive interpretation, harmonization of conflicting provisions. These methods are strikingly similar to the tools developed in Mimamsa for interpreting Vedic texts. In fact, several Shastrakaras have pointed out that Mimamsa can be seen as one of the oldest tradition of legal systems. Just as modern legal systems developed principles to interpret legislation, Mimamsa developed principles to interpret scriptural injunctions. Therefore, the relationship between Laukika reasoning and Mimamsa reasoning is deeply interconnected. Mimamsa does not invent reasoning artificially. Instead, it observes how reasoning operates in real life, then collects, refines, and systematizes those patterns into a rigorous interpretative framework. Through processes like Krodikaraha, systemization, Parishkaraha, refinement, and Vishaya Vishaya Chintanam, analysis of applicability. Everyday reasoning becomes a precise tool for textual interpretation. And this is precisely why Mimamsa remains valuable even today. because its interpretative tools can help us understand not only ancient Sanskrit scriptures, Vedas, but also principles of legal interpretation. Some important analytical principles in Mimamsa I would like to present now. We saw that Mimamsa grew out of reasoning practices already present in society, right? Over time, Shastrakaras carefully observed these reasoning patterns and refined them into a systematic framework for interpreting Vedas. Now let us look at some important analytical principles used in Mimamsa interpretation. Let me start with Badhya Badhaka Bhava, the relationship between the overridden and the overriding. One common difficulty in interpreting texts is the presence of apparently conflicting statements. Sometimes two passages may seem to prescribe different or incompatible instructions. When such situations arise, Mimamsa scholars analyze the relationship between these statements through the concept known as Badhya Badhaka Bhava. In this relationship, the statement that is set aside or overridden is called Badhyam, and the statement that overrides or prevails is called Badhakam. The task of the interpreter is therefore to determine which statement should prevail and which should yield. This is a very similar problem in the field of law. Legal system frequently encounter situations where two provisions appear to conflict with each other. In such cases, courts must determine which rule has greater authority or applicability. Shastrakaras developed systematic ways of resolving such conflicts, ensuring that interpretation remained consistent and rational. Thus, the concept of Badhya Badhaka Bhavaha represents an early and sophisticated approach to resolve textual conflicts. Vakya Bhedaha is another one. When interpreters encounter a passage that contains several elements, it may sometimes be tempting to treat each element as separate rule. However, Mimamsa Shastrakaras caution against doing this unnecessarily. Wherever possible, they prefer to treat the passage as one unified statement unless there is a clear reason to divide it. Why is this important? Because if we artificially split a sentence into multiple statements, we may end up creating additional obligations or meanings that the text never intended. Therefore, interpreters try to preserve the unity and coherence of the sentence. This idea again has a strong parallel in legal interpretation. Courts often try to read statutory provisions harmoniously and cohesively rather than fragmenting them in a way that produces confusions or redundancy. When we look at these ideas together, we begin to see how carefully structured the Mimamsa method of interpretation is. An interpreter trained in this tradition asks questions such as, do two statements actually conflict or they can be harmonized? If there is a conflict, which statement should prevail? Can the passage be understood as one coherent statement rather than artificially splitting it into many? By systematically addressing such questions, Mimamsa Shastrakaras developed a disciplined approach to textual interpretation. In earlier segments, I spoke about how Mimamsa provides tools to interpret texts carefully. We saw how it analyzes sentences, resolves apparent conflicts, and determines references within language. Let us now look at another powerful interpretative principle called Atideshaha. The word Atideshaha literally means extension or transference. In interpretative practice, it refers to applying rules that are prescribed in one situation to another situation that closely resembles it, particularly when the second situation does not have its own explicit rules. In Mimamsa terminology, the situation where complete rules and procedures are clearly prescribed is called prakriti. When another situation arises which resembles the prakriti but does not have detailed instructions, the interpreter understands that the same rules should applied there as well. This idea is expressed in a well-known Mimamsa vakyam prakritivat vikritihi kartavya. This means that a situation resembling the original one should be carried out in the same way as the original. An important point to note is that Atideshaha does not merely transfer a single rule. Often an entire set of procedures associated with the original situation is extended to the similar situation, unless the text explicitly states the difference. This principle was extremely useful in interpreting Vedic texts. Often the Veda describes one ritual in great detail, let's say Agneya Yaga, and later mentions another ritual that resembles Agneya Yaga but does not repeat all the procedural details, let's say Saurya Yaga. In such cases, the interpreter understands that the procedures already described earlier should be followed here as well. Without a principle like Atideshaha, interpretation would become extremely difficult because the text does not repeat every instruction again and again. Interestingly, the same type of reasoning appears in modern legal interpretation as well. A good example in the case Sardar Muhammad Ansar Khan versus State of UP. These examples are there available in the web. I can share the links later. In this case, a dispute arose in an intermediate college regarding seniority between two clerks who had been appointed on the same day. Later, when the post of head clerk became vacant, the question arose, which of the two clerks should be treated as senior and therefore eligible for promotion? Normally, such questions are resolved through clear rules. However, in this case, there was no rule governing the seniority of clerks appointed on the same day. At this point, the court examined the relevant regulations and found that there was a rule for teachers. According to Chapter 2, Regulation 3 of the UP Intermediate Education Regulations, when two teachers are appointed on the same day, the person who is older in age is treated as senior. The problem, therefore, was this rule explicitly mentioned teachers, not clerks. Justice Markandeya Kadju, who decided the case, observed that although the regulation spoke about teachers, the problem being addressed was exactly the same. How to determine seniority when two persons are appointed on the same day. Since there was no rule for clerks, the court applied the same principle, Atideshaha, that was already provided for teachers. Thus, the court held that the older clerk should be treated as senior, just as the older teacher would be treated as a senior in similar situation. Interestingly, the judgment itself refers to Mimamsa reasoning and explains that this type of extension resembles the principle of Atideshaha. From the perspective of Mimamsa, the reasoning becomes very clear. There was one situation where a rule already existed, teachers appointed on same day. Another situation arose, clerks appointed on the same day, for which no rule had been provided. However, the two situations were essentially similar in nature. In both cases, the problem was determining seniority when two persons were appointed on the same day. Therefore, the court extended the existing rule to the similar situation. This is exactly what atideshaha means. When a rule exists for one situation and another situation resembles it, the same rule may be applied there. However, Mimamsa scholars emphasize that such extension must be done carefully and logically. The interpreter must first determine that the two situations are sufficiently similar in purpose and structure. Only when such similarity exists can the established rules be extended. If the situations are fundamentally different, then applying the same rule would be incorrect. Thus, atideshaha is not arbitrary extension but a disciplined interpretative method based on structural similarity. Next thing I would like to go is Nashtashva Dagdharatha Nyayah. Listening to the maxim, this sounds like a medieval story rather than a legal principle, right? But like many classical Mimamsa maxims, it expresses a very practical rule of interpretation. The story behind the maxim goes like this. Let's say two travelers are journeying in separate chariots. During the journey, one traveler loses his horses, so his chariot cannot move. The other traveler suffers a different misfortune. His chariot is burnt, but his horses survive. Now, if each person insists on preserving his own arrangement, neither can proceed. One has a chariot without horses, and the other has horses without a chariot. The practical solution is obvious. The surviving horses are attached to the surviving chariot, and both travelers continue their journey. Thus, instead of losing everything, they combine what remains useful and move forward. This simple story expresses an important interpretative principle. When two authorities appear to conflict, the interpreter should try to preserve what can still function from both, instead of discarding one completely. In other words, the goal is harmonization rather than destruction. The reasoning appears very clearly in the case Tribhuvan Mishra versus DIOS 1992. In that case, the judge faced a difficult interpretative situation. There were two earlier division bench decisions of the High Court and they seemed to point in different directions. At first glance, they appeared to conflict with each other. In such situations, the normal practice in the court is to refer the matter to a full bench, which usually consists of 3 or more judges. The full bench would then examine the issue and resolve the conflict. However, referring a matter to a full bench takes time and judicial resources. So the judge in this case tried a different approach. Instead of assuming that the two earlier rulings were irreconcilable, the judge examined them more carefully. He looked at the context, facts, and scope of each decision. By doing this, he realized that each judgment could operate within a slightly different field. In other words, each decision could be interpreted in a more limited scope so that both could continue to stand without directly contradicting each other. In explaining this reasoning, the judgment referred to the Mimamsa principle Samanjasya, that is harmonization, and illustrated it through the maxim Nashtashvadagdaratha Nyayah. Just like the travelers who combined the remaining horses and chariot, the court combined the useful parts of both precedents so that they could coexist. This principle teaches an important lesson of legal interpretation. In the law, we often encounter situations where two statutory provisions appear to conflict or two judicial precedents seem inconsistent. The instinctive reaction may be to discard one of them, but Mimamsa encourage a more refined approach. Instead of immediately destroying one authority, the interpreter should first attempt harmonization to see whether both can continue to operate within appropriate limits. Modern legal theory calls this approach harmonious construction. But long before modern jurisprudence articulated this doctrine, the Mimamsa tradition had already expressed it through the vivid illustration of the lost horse and the burnt chariot, which we call Nashtashvadagdharatha Nyaya. Laghava Nyaya is another one. The word Laghava literally means lightness or simplicity or economy. In interpretative reasoning, this principle suggests that when two interpretations are possible, the simpler and more economical interpretation should be preferred, provided it adequately explains the situation. The underlying idea is that interpretation should avoid unnecessarily complexity. If a rule or statement can be understood through a clearer and straightforward explanation, we should not adopt a complicated interpretation that introduces unnecessary assumptions. In other words, the interpreter should prefer the explanation that requires fewer assumptions and produces greater clarity. This principle is sometimes described as interpretative economy, the preference for a solution that is simpler, clearer, and more workable. In many interpretative situations, especially in law, there may be multiple possible criteria for making a decision. Some of these criteria may involve complex and subjective considerations, while others may be simple and objective. The principle of Laghava encourages us to prefer objective and straightforward criteria because they reduce ambiguity and because they reduce ambiguity. This makes interpretation more predictable and fair. An interesting example of this reasoning appears in the case Vinay Khare versus State of UP. The dispute in this case arose in the context of a competitive examination. Two candidates had obtained exactly the same total marks. The question therefore arose, how should their relative merit be determined? There were two possible approaches. One approach was to give preference to the candidate who had scored higher marks in the oral interview, and the other approach was to give preference to the candidate who had scored higher marks in the written examination. Now the court examined which method would be more appropriate. The marks obtained in the written examination provide a clearer and objective measure of performance. They are based on a structured evaluation of the candidate's knowledge and abilities. On the other hand, oral interviews involve many subjective factors, right? During an interview, evaluators may consider aspects such as personality, dress, manner of speaking, or general impression. These factors are often less precise and more susceptible to variation. Because of this, interviews can sometimes create greater scope for arbitrariness or favorism. In deciding the case, the court preferred the simpler and more objective interpretation. It held that the candidate who scored higher marks in the written examination should be placed higher in the merit list. The reasoning was that relying on written marks provides a clear and straightforward criterion, whereas relying on interview performance introduces greatly complexity and subjectivity. Thus, the court effectively adopted the interpretation that minimized complication and maximized clarity. This reflects the spirit of the Laghava Nyaya. The principle of Laghava, therefore, reminds us that interpretation should strive for clarity, economy, and simplicity. When two explanations are available, we should prefer the one that require fewer assumptions, introduces less complexity, and produces a clearer and more objective rule. Such an approach not only improves logical reasoning but also strengthens fairness and predictability in legal decision making. The maxim Laghavan Nyayaha demonstrates that Mimamsa Shastrakaras were deeply concerned with methodological clarity in interpretation. Their goal was not merely to understand texts, but to ensure that interpretation remains logical, consistent, and practical. As the decision in the above said case, Vinay Khare versus State of UP, illustrates that same preference for simplicity and objectivity continues to guide reasoning in modern courts. Thus, once again, we see the interpretative insights developed in the Mimamsa tradition centuries ago still resonate strongly with contemporary legal reasoning. Next thing I would like to explain is Upalakshana Nyayaha, interpretation by indicative inclusion. Upalakshana Nyayaha, the word Upalakshana means indication or representative mention. In interpretation, this principle means that sometimes a text mentions one or a few examples, but the intention is to include other similar situations as well. The examples mentioned are not exhaustive but illustrative. Thus, the interpreter should look beyond the literal wording and understanding the underlying purpose of the rule. A classical verse from the Tantravartika of Bhattapada explains this idea beautifully. Kakebhyo rakshiyatam annam iti balopi choditaha upaghata pradhanatvat shvadibhyo nanu rakshati. The meaning of this verse is, if someone instructs a child saying protect the food from crows, the child does not merely drive away the crows, he also protects the food from dogs or other animals that might spoil it. Why? Because the real intention of the instruction is to prevent the food from being damaged. The mention of crows is only an example. It represents all possibility sources which can harm the food. This is exactly what Upalakshana Nyayaha teaches. A particular example mentioned in the text may stand for a broader category. A striking example of this reasoning appears in the case Uday Shankar Singh versus branch manager LIC. In this case, the petitioner was riding a scooter when he was hit by a truck. As a result of the accident, one of his legs was severely injured and eventually had to be amputated. The petitioner then claimed compensation under his life insurance corporation policy. However, the relevant rules of LIC provided compensation only in two situations: death or permanent disability. The rules also defined permanent disability in a very specific manner. According to the rule, permanent disability meant loss of both eyes, or amputation of both legs, or amputation of both hands, or amputation of one hand and other leg. One hand and one leg, sorry. Since the petitioner had lost only one leg, the LIC rejected his claim. They applied what lawyers call the literal rule of interpretation, which in Mimamsa terminology corresponds abhidha or vachyartha, the direct or literal meaning of the word. According to this literal interpretation, the rule did not explicitly include the loss of single leg, so compensation was denied. When the matter reached the court, the judges adopted a different interpretative approach. They looked beyond the literal wording and examined the purpose behind the rule. What did the policy why did the policy provide compensation in cases like loss of both legs, both hands, or loss of eyesight? Clearly, the intention of the rule was to compensate a person who had suffered serious and permanent physical disability affecting normal life and livelihood. From this perspective, the loss of one leg was also a very serious and permanent disability. Even though the rule did not explicitly mention it, the underlying purpose of the rule clearly covered such a situation. Therefore, the court applied reasoning similar to the Upalakshana Nyayaha principle. The specific examples mentioned in the rule, loss of both legs, both hands, or both eyes, were treated as illustrative cases of severe permanent disability, not as an exhaustive list. Thus, the court allowed the petition and granted compensation. From the standpoint of Mimamsa interpretation, the logic becomes very clear. The rule mentioned certain examples of permanent disability, but those examples were meant to represent a broader category of severe disability. Just as the instruction kakebhyaha dadhirakshiyatam actually means protecting it from crows, all creatures that may spoil, the rule about loss of limbs or eyesight was meant to cover serious permanent impairments generally. Thus, the court interpreted the rule in the light of its intention rather than merely its literal wording. This principle has great relevance in modern law. If courts were to follow the literal wording alone, many genuine cases could be unfairly excluded simply because they were not explicitly listed in their rule. The principle Upalakshana remains as that interpretation must consider the purpose behind the provision. When a text gives representative examples, the interpreter should understand them as pointing to a wider class of situations. Another thing I would like to mention is Pratinidhi Nyayaha, the principle of substitution or representation. Pratinidhi Nyayaha, the word Pratinidhi literally means a representative or substitute. In interpretative reasoning, the principle states that when a person or object specifically mentioned in a rule is unavailable, another person or object that is functionally equivalent may act as a substitute. In other words, if the exact authority or instrument prescribed in the text cannot operate in a particular situation, the law does not remain paralyzed. Instead, the nearest equivalent authority may perform that function. This ensures that the purpose of the rule is fulfilled even when the original mechanism cannot operate. Why such a principle is necessary? Rules and statutes are usually drafted assuming normal circumstances, but real life often presents unexpected gaps. Sometimes a specific authority mentioned in the rule may not exist or may not be available in a particular situation. If interpretation rigidly insists on the exact wording, the law may become completely ineffective. The principle of Pratinidhi Nyayaha prevents such paralysis by allowing a functional substitute. The emphasis here is not merely on the designation mentioned in the rule, but on the function that the authority is expected to perform. An interesting example of this reasoning arose under the TADA Act, the Terrorist and Disruptive Activities Prevention Act. Under this law, a person arrested under the Act could apply for bail before a designated judge. The designated judge in such cases was supposed to be the district judge. However, in one district, a practical difficulty arose. The High Court had not yet posted a district judge in that district. As a result, the person who had been arrested under the Act had no authority before whom he could apply for bail. Because of this situation, he accused the accused remained in jail for more than 8 months, simply because the required judicial authority was not available. Clearly, this created a serious problem. The law allowed a person to apply for bail, but the mechanism for exercising that right was absent. The matter eventually reached the higher court. The court then examined how the law should function in such a situation. If the rule were interpreted strictly and literally, the accused would have to remain in jail indefinitely until a district judge was appointed. But this would defeat the very purpose of the legal provision allowing bail. Therefore, the court applied reasoning similar to the Pratinidhi Nyaya. The court observed that although the statute mentioned the district judge, the senior-most additional district judge in the district performed almost the same judicial functions and stood closest in authority to the district judge. Therefore, the court held that the senior-most additional district judge could act as the substitute authority and hear the bail application. From the perspective of Mimamsa interpretation, this reasoning fits perfectly with the principle of Pratinidhi. The law specified a particular authority, but that authority was not available in the actual situation. Instead of allowing the law to become ineffective, the court allowed the nearest functional equivalent authority to perform the same role. Thus, the additional district judge acted as the representative or substitute for the district judge. The purpose of the rule allowing a bail application to be heard was therefore preserved. This principle highlights an important aspect of interpretative reasoning. The law should not be interpreted in a way that makes it impossible to function. When the exact mechanism prescribed in the rule cannot operate, the interpreter must look for the closest substitute that can fulfill the same purpose. This approach ensures that the spirit and objective of the law are maintained, even when practical difficulties arise. So, throughout this talk, we saw how several of these principles operate in modern legal reasoning. The principles of Atidesha helps us extend rules from one situation to another similar situation when the text is silent. The maxim Nashtashvadagdharatha Nyayaha encourages us to harmonize apparently conflicting authorities instead of discarding one of them. The principle of Laghava reminds us to preserve interpretations that are simple, objective, and economical. The Upalakshana Nyayaha teaches us that sometimes the examples mentioned in a rule are illustrative and represent a broader category, and the principle of Pratinidhi shows how a substitute authority may function when the exact one mentioned in the text is unavailable. What is striking is that these principles were formulated many centuries ago, yet we find the same reasoning appearing repeatedly in modern court decisions. This shows us something very important, that Mimamsa is not merely a historical curiosity or a ritualistic discipline. It is in fact a highly sophisticated theory of interpretation. For students of law, therefore, studying Mimamsa is not simply studying an ancient philosophical system, it is learning a method of reasoning about texts, rules, and authority. And that ultimately is what both scriptural interpretation and legal interpretation seek to achieve: a careful, logical, and principled understanding of authoritative texts. With this, I thank one and all for this great opportunity, and I will hereby conclude this.
Good morning, sir. This was a wonderful lecture. I have a doubt. if there is a Mimamsa interpretation rule, but the Parampara has interpreted that in the other way for thousands of years, then for example in Nyaya Shastra we call that as Shishtachara, Avagita Shishtachara Parampara Praptaha iti. But should we use the Shishtacharatva as the pramana to override the Mimamsa interpretation, or should Mimamsa interpretation prevail even despite the Shishtachara being the other way contrary to it?
Can you present a scenario?
Sir,
see, without a scenario, we can't say. But I can understand. I can understand where your question is coming from. Mimamsa
override the Mimamsa rules.
Shishtachara may override the Mimamsa. Do not prescribe the rules, Kanna. I hope you understand Tamil as well.
Yes, sir.
மீமாம்சா வந்து ரூல் போடுறது இல்லை, இருக்கிற ரூல்ஸை இன்டர்பிரேட் பண்ணி அதை சரியான முறையில் புரிஞ்சுக்கிறதுக்கான ஒரு ஃப்ரேம் ஒர்க் தான். ஸோ சிஷ்டாச்சாரம் ஸ்மிருதிஹி வேதா இந்த கிரமத்தில் ஒவ்வொன்றும் பிரமாணங்கள், அதாவது ப்ரெஸ்கிரைப் ரூல்ஸை சொல்லி கொடுக்கறது வேற, சொல்லி கொடுக்குற ரூல்ஸை இன்டர்பிரேட் பண்ணுறதுக்கு தானே மீமாம்சா.
I am Venugopalan here. Shishtachara, we will not override any practice of Shastra principle. Normally, because the Shishtachara is being formed by following the Vedic the injunctions for over a period of time, thousands of years. There's only those practices will become Shishtachara.
That is why I asked for a scenario, sir.
There will not be very conflict between Shishtachara and the Shastra per se. Sometimes, that's why, some Nyaya of Mimamsa principles will not clash with Nyaya rules, because they both travel in a different path. Yeah, Avigita Shishtachara Namita Shrutimodita Kartavyatakam. That is something different. Okay, I understand that. But Mimamsa travels in another path. It will override with other principles. But thank you, Hariharan ji. Actually, here, yesterday I was speaking to NKT Pandurangi Mahodaya, and we have planned to introduce open electives for law students. Even when I was brought 3 years back by Vice Chancellor here to be here in this organization, he instructed me to develop a course for the law students on Nyaya Shastra as an open elective. Every semester, for first year, 2 semesters, second, 8 semesters, you have time. Without disturbing the last 5th year, for 8 other semesters, you will have one OE starting from Nyaya, this thing, from Tarka Sangraha, how the Nyaya school functions, then Mimamsa school, then Dharma Shastra school. Every school would be, the salient features of every school will be introduced to the students of law, of Shastra, in a 3-credited course, 45 hours course. Now, the Purna Prajna Vidyapeetham of Karnataka have now promised us to develop such courses for the students of Shastra. It can be, of course, duplicated elsewhere also, but the Shastra students will be, as management, will be very much interested in having such courses here. They will introduce, they will give you certificate also. So whenever you go out and practice in the public, this will be an added advantage for all the students of Shastra who are the practitioners of modern law. Will also have an additionally equipped with the traditional knowledge of legal systems, how to interpret, and they would be the better advocates when they go out in the public. So this facility has now been drawn, and things will be in pipeline. We will see these ideas in effect from next year onwards, I hope. Thank you, Hariharan ji.